Hear me?
Yeah,
Okay.
yes, I think perfectly fine.
Yeah, perfect. So, good afternoon, everyone. I am Nachiketa Mittal. I am founder and director of Virtual Law School. I'm very happy to welcome all of you today on the World Environment Day and wish you all a very peaceful and healthy World Environment Day. In fact, it's quite befitting given this scenario, the tough circumstances that we have been living in since past 2 to 3 months. It makes it all the more relevant, I guess, for this year in 2020 to value World Environment Day in a lot more sense, to bring in a lot more diversity from a perspective, being lawyers of environmental law, teachers of environmental law, and also civil society activists, scientists, and even a common man, believe. And above all, I think we all have been seeing since a long time lot of discourse and debate with regard to holding the state accountable, holding the governments accountable with regard to the executive actions vis-a-vis different kinds of plans and policies and governance issues of environmental governance as such. So in that regard, it's a wonderful opportunity for all of us to debate. And I really welcome all my panelists here, and also the students and the law teachers who are in the audience for an important session where today we are going to revisit the environmental law teaching as such. Because my idea behind this entire context today was that when we hear a lot of speeches, debates in general, what could we do in our own jurisdiction as the law teachers? Because I'm a law teacher and I have with me today the panelists, which is a composition of lawyers and the law teachers together. So we all can always think about in our doing our bit. For example, I am a law teacher and I have just recently left the active university teaching and have established this virtual law school just in late April. So it gives me pleasure also to tell everybody in the audience today that we started on April 25th, sir. The inauguration was done by Honorable Justice Sikri, Honorable Justice Corinne Joseph, former judge of Supreme Court, also by Mr. P.K. Malhotra, the former law secretary, then Mr. Rajiv Luthra, the founding managing partner of Luthra and Luthra, which is now LNL Partners, Mr. Siddharth Luthra, who is a senior criminal lawyer in the Supreme Court, also Professor Shanta Kumar, the Vice Chancellor of Gujarat National University, Professor Manoj Kumar Sinha, Director of Indian Law Institute, Professor Yogesh Pratap Singh, Registrar of NLU Odisha, and a lot of other lawyers and friends who came forward on 25th of April for helping me inaugurate and launching the virtual law school. Now, since then, my dear friends, and also my dear colleagues, member, I really feel happy to tell everybody that from 27th of April, we started off pro bono law teaching, and till date, we have covered 5 weeks of rigorous pro bono law teaching, which has been spanning over 6 days a week, 5 hours a day, 8 subjects of law, starting with the law teaching from day one by Honorable Justice Sikri. Then we also had one of the judges, sitting judges of Madhya Pradesh High Court, who taught a full course on CRPC. At the same time, we had, senior advocate Mr. Siddharth Luthra, who covered some aspects of bail jurisprudence, and then some of the lawyer friends like Mr. Abhijit Sinha, who is a known arbitrator in Delhi, who covered the entire 25 hours of course on arbitration. In fact, also amongst the audience, I have Dr. Kasturi Bhagat, who has been kind enough to teach the entire portion of family law. So and so forth, along with Dr. and Professor Yogesh Pratap Singh, Registrar of NLU Odisha, who has been teaching constitution law. So it's been a journey for over a month now, and we have been doing pro bono, sir. And I'm also happy to tell everybody some of the virtual law school students have also joined in today. Some who might not have joined in the virtual law school formally, but are also participants today. So they all would know that over 500, close to in fact 600 students I've been teaching at the virtual law school for over a month now. And I can see now Professor Pushp Kumar is joining. Yeah, so sir has now joined. Sir, can you hear me?
I can.
Sir, can you hear me?
I can hear you. Yes.
Okay, great. So I welcome all the panelists now. We have a complete panel now with us, my dear friends. So just taking them through the journey of the virtual law school till we, waited for you to join in. So let me introduce to everyone the panel speakers for the day. So we have my dear friends on the screen, Professor S.K. Gupta, who is a professor of law in Banaras Hindu University. So welcome, sir, today on board. And Professor Gupta is also heading the Legal Aid Center and executive director of the Clinical Legal Education in Banaras Hindu University, which is really vital for me also to explore from the perspective of environmental law teaching, to which I will come in a short while. So welcome, sir. Thank you for coming on a very short notice, but valuing my words, and also so that we could benefit from your expertise. My dear friends, I also welcome Dr. Pushp Kumar. So Dr. Pushp Kumar has been teaching in University of Delhi for a long time, has also taught in Hidayatullah National University, and has also been a distinct Fulbright scholar to Harvard Law School in 2013 and 14, and has taught and delivered lectures in a number of law schools in the United States, and is widely published. And alongside, sir, I tell one thing to a lot of law teachers, but there's something which is distinct in you, which is distinct in most of us, which is not distinct in me, that you have a distinction of also having practiced at the bar. So in India, at least, most of the law teachers, we don't have a background of practicing at the bar and then coming to law teaching. So you have that sort of a distinction of matching the legal practice, your experience there, and then coming to the active and full-time law teaching. So that adds another dimension, which at least I don't have, and many of the friends I have known in the law teaching doesn't have. So welcome on board, sir. You have been
Thank you very much
all these years and writing very profusely and predominantly on the environmental law subjects. So friends, I'm also happy to welcome Mr. Shawaik Siddiqui, who is a lawyer and founding partner of Indian Environment Legal Organization. So Shawaik, I have known you for over 10 years, maybe 15, I believe, since the time I began to work with Rural Litigation Entitlement Kendra to tell all the law students RLEK filed the first environmental PIL in the country, which we all study as limestone quarrying case in environmental law. So I had fortune after law school Bangalore to work with them for a couple of years and heading their projects. So that is the time I and Shawaik, we met at UNDP forums, I remember, making presentations, on number of justice projects. So Shawaik has been, sir, doing lot of work, in fact, has been committed only to the agenda of environmental law ever since I have known him for last 15 years, probably. Right. So Shawaik brings in a very good diverse perspective on environmental law litigation. In fact, thank you, Shawaik, you could make it today. I know you had an urgent filing today with the recent mishap in Gujarat. Right, so that's the level of work he does, keeping up to date, pinpointed, sort of law practice on everything that's happening with regard to environmental law across the country. Right, so even
thank you for the opportunity.
Yeah, thank you, Shawaik. So, my dear friends, now let me take you through this entire process. As I have talked to the panelists, let's start the discussion with Dr. Pushp Kumar today. So in the first round of the discussion of the panel speakers, I have a few sets of questions, as we discussed earlier, which is going to benefit.
Hey, number internet cut out, pa.
Yeah, I think I sort of lost a signal, but you all can hear me now. You all hear
Yes.
me? Yeah. Okay. Yeah. So Dr. Pushp Kumar, my first question to you is that how do you assess this, and what is your take on revisiting the law teaching as a subject in general, if going by your experience?
Thank you very much. First of all, I would like to congratulate you on this, a new initiative that you have taken. Can you hear me?
Yes, sir.
Is it audible?
Yes, indeed.
Good. Yeah. First of all, I would like to congratulate you for initiating such a wonderful, experiment, virtual law school, and bringing, very learned people on platform to discuss different topics, and also creating this panel, a very learned, experts here. So for discussing the World Environment Day, where we are going to discuss about the environmental law as a subject, how we teach, and what kind of revisiting we need require in the teaching of environmental law. In fact, your question really gives me a lot of thinking about what do we do in teaching environmental law. Through my experience of teaching law, I always felt that environmental law, when the Bar Council of India introduced as a subject, it came out as an optional subject. When it was an optional subject, we gave a second treatment to that subject, and not really full-fledged approach or a seriousness in teaching the subject. Then the Bar Council itself has found that this is not doing justice to the subject, that we need to make it a compulsory subject. So now of late we have introduced this as a compulsory subject for all law courses. It is no more an optional subject. So where every law student who are coming to the law school have to one has to study environmental law as a a compulsory subject. Why? The reason is that the lawyer that he is going to make should understand all the implications of life, and the life is possible only when a good environment is there, and only when the good environment is there, our life, all the resources, everything can be enjoyed properly. A healthy life would be possible. Then all other rights can be enjoyed. So whatever be the constitution that we study, all the other subjects we study, everything could be possible only when we have good environment to live with, good water to drink, and good air to breathe. This is the basic thing that one has to understand, not only law student, for everyone. Every human being should know that environment is important. And when environment gets degraded in different manner due to pollution or due to some kind of devastations happening or accidents happening like Bhopal, then the law comes to rescue, to provide solutions and remedy, and to also provide justice. So as a law student, how you will understand this environmental law as a tool to protect environment and to provide remedies to the people. So that's how I think we have devised the curriculum, so that every law student will get the message before becoming a lawyer, how he can become an agent of protecting justice and to protect environment. This is what we visualized. But my experience is that this is not really working in that manner. To be very frank with you, you have also taught environmental law, and I've been doing it for several years in different universities. Usually we think that the teachers as well as the students, we think that it is an easy subject, and anyhow the people students will be able to pass through. So there is no much effort needed for this subject, and moreover everybody knows about environment, and there is no difficulty in understanding this subject. So it can be like that. That should not be the case. Now we are in a difficult times where our survival is in a question mark. Climate change, biodiversity loss, and all kinds of other environmental calamities that we are facing here in the world, not only in India, have taught us and given us a message that if you mess with the environment, we cannot live peacefully. Coronavirus, this lockdown has given much more understanding about this. So I think we need to capture this as an opportunity to look at how we will reshape and revisit our environmental curriculum, so that we all will have a kind of a commitment to do justice to environment, and so that we will have a proper development, drawing all the resources from the nature. I see that see when when we do we have one more minute to discuss this, or you have to go to the different round? I want to just elaborate this point with one example. What we lack. Yes, Nachiketa, can I go ahead? I could not hear you.
Please go ahead, sir. Go ahead.
Yes, please. Yeah.
Yeah.
So revisiting the subject, why? we need to think about is, one is developing the sensitivity that is required for the purpose of understanding the subject. That is very important for every law student, to get that kind of a sensitivity to understand and appreciate environment, and to understand his role as a crusader for protecting environment. That is the first thing that has to come into some way into the curriculum. And the role of the teacher becomes very important here. And we need to inculcate some kind of interest and encouragement to the students, number one. It should not be taught like, career-oriented subject, or one among the subjects like, we treat others. And this is a very special subject. It really, touches the core of our life, and it gives meaning to our life. So in that context, this is a special subject, and it has to be understood in a special context. So the sensitivity and the real understanding about the subject has to be taught to the student. And secondly, the teachers have a great role in making it a very passionate subject to teach, number one. Number two, we have to mix the practical aspects of the subject. For example, taking the students to the nearby places like field visits, and creating some kind of a skills to the teachers with the help of internships like that. I think those aspects have to be combined with the environmental law teaching. Then this curriculum will work very well. It will yield the results. And in my own university where I teach, these two things are not possible. I'm really struggling to combine these field visit or the internship kind of things. So the theoretical things are not really sufficient, even though that will really enlighten the people, but it is not very sufficient. So that way, I think we need to relook at our curriculum. Over to you. I think you have to unmute your mic. I could see that your mic is still muted.
Yeah.
Send him.
Yeah. Can you hear me now?
Now we can hear you.
Slide, sometimes you have internet lag, which leads to it. Okay, so now so one thing I really appreciate that you have been very frank in putting forth your opinion as a legal academic, that what kind of issues and challenges that even you are facing in your university, so to say, in terms of streamlining and trying to strengthen the entire set of, I would say, environmental law teaching. Because as I would say as well, having taught environmental law, that what is my experience even across the national universities and the private universities, I have taught in both. So my experience is that the environmental law teaching is generally taken as or understood to be a side dish paper. It's not a mainstream paper. It's not allotted looking at the expertise or subject matter expertise of a professor. Right there, in fact, in most of the national universities, I'm sorry to say, but I'm clear when I speak academically. In fact, that is the strength of us as academicians, that we can speak very frankly and robustly. Right. So, in fact, even in the national universities, it is given to somebody who is just a beginner law teacher or somebody who could be a research associate. Right, without looking at the expertise, and even the students are, I would say, put through a culture that they begin to think that, oh, this is a paper which means an easy scoring. There's nothing great about it. You just have to mug a few MC Mehta cases and that's done. You're done with the environmental law, and you would begin to claim also an expertise over it.
Yes.
So that's how, unfortunately, has the scene be. So, but yeah, moving forward, to Professor Gupta. Sir, you have been dealing in teaching environmental law in Banaras Hindu University, one of the very old, leading law schools of the country, which has produced several stalwarts at the same time. So, what has been, sir, your experience? You have a greater exposure in that sense with a bigger set of university and having also lectured across India in different other law schools. That where do you see the environmental law teaching has crossed over generations? And what is the present kind of scenario or a change at which you stand in Banaras Hindu University Law School as such?
So very good afternoon to all of you. Can you hear me, please?
Yes, sir, we can.
Very much.
So my regards to all of my colleagues, panelists, and students who are participating in this webinar. I'm particularly thankful to Dr. Nachiketa Mittal ji, who has given me this wonderful opportunity to share my views and to learn from my colleagues and participating students. In fact, let me share some personal experiences. Let me acknowledge first that from last many years, I have not been getting opportunity to teach a subject that is called environmental law, though it is my favorite subject, and I have done some research work on that. You have asked the history of teaching of environmental law at Banaras Hindu University and elsewhere, and what is my experience about that. Of course, I belong to a very old institution that is called nowadays the traditional universities, and perhaps I should feel some proud to say that during 1960s and 70s, some of the law schools, including Banaras Law School, has done a lot of service so far the legal teaching is concerned. It was my law school that initiated the 3 years course first time, and perhaps it was Professor Anandji, my dean, who initiated a full-fledged program of clinical legal education. Of course, he was very much influenced with the American model. He was PhD from the Yale University, and my law school was very fortunate in the sense that most of the professors and deans, they were educated from the Harvard, Yale, and other leading law schools of that time. And let me say that my law school has been built from the generous grant of the Ford Foundation. The entire building, if you can see on the internet, the entire huge building of the Banaras Hindu University has not been built with the help of a single paisa from the government of India. All the huge building has been built by the.
Sir, but can we come back to a very interesting issue that that where do you see that over the years the environmental law teaching stands in BHU as such?
I'm coming on that. So it was 1976 when one of my teachers, under whom I did the LLM dissertation, my reverend teacher, Professor C.M. Jariwala, who is considered as one of the leading law teacher across India, and he has contributed a lot of articles in various journals, and it was perhaps 1976 he started a seminar course in environmental law. In my law school, the environmental law teaching was started in the form of a seminar course. So he used to take only 20 to 30 selected students, and there was no annual examination. It was a seminar course, and the idea was that since the subject is growing, so he used to take at least 10 to 20 lectures, and then he used to give some project work, and he used to send the students in the field, and the students used to go in the field, collect the data, field experience, and write down their project work, and they used to present before the teacher. In fact, I did my LLB from the Allahabad University, My batch was 1988 and it was completed in 1990. But that time the environmental law was not a subject. When I joined my law school in 1997, I was the teacher who was given 1 or 2 class to teach in the seminar course. And one thing more, subsequently, as my friend Pushpa Kumar has said that perhaps it was the 1984 Bhopal mass disaster that had changed the entire discourse of environmental law in India, perhaps. So you can divide the environmental law teaching as well as the environmental law research or environmental law movement or environmental law consciousness before pre-Bhopal and post-Bhopal. So Bhopal can be considered as a landmark event that has changed the whole discourse of environmental law so far the Indian environmental law is concerned. And that's why perhaps the Bar Council of India has thought fit to introduce the environmental law as a compulsory paper. One thing more, what is my experience about the other law school? In fact, I have not done any empirical study. And but one thing more, I would like to appreciate the contribution of National Law School Bangalore and particularly Professor M.K. Ramesh. I got in fact, perhaps it was 1997 when Professor N.N. Mitra sir, who was the Vice Chancellor at that time, he visited along with Professor Ramesh to my law school and he delivered a lecture. And then we organized a program for the local self-government. And subsequently, we came to know that the World Bank has given a huge project to through the Ministry of Environment to the National Law School Bangalore. And subsequently, we were invited to be trained. So it was in the 1999 when I went to National Law School Bangalore and got a refresher course of 21 days there. And then again, environmental law course in 2000. Again, I went and got privilege to participate. And I saw that what Professor Ramesh has done, it was a very good contribution, Sira, as you have pointed out. And I have learned so many things during these 2 courses. And I particularly I appreciate the broad vision of Professor N.N. Mitra, who spoke at least 3 hours only on the issue.
If you don't mind, I'll then move on, sir. I'll then move on if you don't mind to share. There's another very interesting aspect which I got from what you mentioned, that the entire discourse has changed. BHU started off as a seminar course, and in the very initial time, it was these few were selected, and then they were taken up, to be enrolled in the environmental law course. As opposed to that, it was now compulsory, but still in some way it has lost its sanctity, as I would say. Now, Shavaik, that you have been an environmental lawyer throughout, right? You are a founding partner of Indian Environment Law Organization. And as I have known you for years, that you have been practicing litigating at in different courts across the country, right, about the environmental issues. So, and but yes, you have been a law student at one point in time as well from Aligarh Muslim University. That's again, one of the very landmark institutions of the country. So what is your take that when even I had earlier occasions to talk to you, what do you think are the gaps which are on the practical side, and you would want to say that these are the gaps which need to be plugged? You may probably suggest your answer in the second round of a discussion, but what are those gaps that you see? You may get, because a lot of interns also in your office.
Right, Nachiketa, thank you again. So I'm not as eminently qualified as my colleagues are, but I'm a quasi-academician as well. So I teach Government of India twice a year, almost all the Government of India institutions, from Indira Gandhi National Forest Academy to April National Water Academy. Now, very quickly, the basic point has already come. That being that there is a very visible disconnect between the practice and the teaching of environmental law. I would probably like to jot down very quickly 3 points and begin from the counter narrative that might enrich the discussion probably. The counter narrative to Dr. Push Kumar's argument that environmental law is not to be taught as something which is pure economically driven or professionally driven. It has to be a service. Actually, I have discovered both in the teaching. For a long period, I used to teach at ILI, which is just in opposite to the Supreme Court. They have a PG diploma in environmental law. There is a problem with this narrative that environmental law practice is a service. Now, we all of us struggle with it almost on a daily basis. It is now very clear after NGT Act and with the Green Code starting in a full-fledged way that environmental law is a as lucrative career as any other practice or any other domain is. And that is the reason that I feel that what is not done enough at law schools is that two things are not done in classrooms. One, the vigor in the approach to law teaching, to environmental law teaching, is missing. It is still taught as something which is, as others have, which is a side subject, something which is a cause and which is a public spirited thing. Two things are not said. One, it is professionally lucrative. Two, you have the opportunity to contribute to the domain knowledge, to the rights discourse. You see, under environment, we have got the entire mini constitution under Article 21, where the rights discourse has been developed. We have been having tremendous debates in terms of moving from positive right to the negative rights. You see judgments of Justice Iyer, Justice Bhagwati, and so on and so forth. You had the entire discourse changed due to the environmental law jurisprudence that has come into being. And that is something that we are not able to tell our students, that here is an opportunity to make money. For example, practice as good as the patent law practice, so the intellectual property which was lucrative in our times, or the cyber law which has come later when we started practicing and our practices have matured. So we have not been able to link the professional part, the knowledge domain part, to the teaching which happens in the classrooms. And if I may add very quickly that what happens is with academician is that there is a certain kind of a current affairs interest which is required to be linked to environmental law teaching. Now, since environmental cases are happening far and beyond, some gas leak has happened in Vizag, some elephant corridor is affected somewhere far away, some forest diversion has happened somewhere in Uttarakhand. Now, we are not able to bring that to the classroom, and therefore it is still in the teaching very theoretical. We are still stuck at Bhopal. With no offense, we just had the mention of Bhopal. We didn't have the mention of Vizag. We are still stuck at RLEK case. We have not touched Godavarman, which is the largest mandamus in the history of the Supreme Court of India, which is still going on. We're not talking about those things in the classroom. So are not finding agitated enough to get into the environmental practice, and they're not taught that it is the existence and it is the future. So, and then the third very quick point is that in law teaching, the environmental remedies are taught to be very limited. It is still a PIL law teaching. It is still told that it is a PIL kind of a thing. We are not told the kind of remedies and the Environment Protection Act at a district level, which a lawyer can go back to his hometown and practice. We do not know about those remedies. Not many people know where is the appellate authority under the Act, for example. So we are not vigorous and rigorous about environmental law teaching, and there's this huge disconnect. I think I'll stop here and take it to the second round.
Right. Okay, great. Thank you, Shavaik. I really agree on that note. In fact, when Dr. Pushpkumar will probably come back, we'll definitely take this issue, and I mean, just for the purpose of our discussion academically, that I was also hearing, that how probably there's this kind of a difference, that should we see it as a lucrative option or not, or should we only label it and tag it as a service, and that could probably make it not too attractive as a lawyering for the students. And that's, I guess, probably is one of the reasons why it has always been on the back seat, as opposed to any other kind of legal practice, which is always a first choice for the law students. So in fact, I also personally believe that, not being a legal practitioner, my dear student friends, if you're hearing that clearly, that it's not that the environmental law is not a lucrative option, or that you also will not have, sufficient money to in that particular litigation for you to survive, to maintain yourself, to in fact go let your practice flourish. It's not so, right, Shivai? There's sufficient means to sustain yourself. Only that
Oh,
you
people
should
have
look.
created empires,
Yeah,
Nachiketa.
yeah,
People have
yes, right.
created
Yeah, I
empires.
know. So I'm trying to create a difference that you should not view it to be commercially exploitative, but at the same time, it's going to give you abundance to keep yourself, in a good sort of social position. That's how I want to make a distinction, right? Because
Right.
in
You can
that
do
sense,
both.
yeah, in that sense, everything can be commercially exploited. It depends on the kind of practice, which is not. I would want. I don't want to disillusion a lot of students on that particular aspect as such. Right. Okay. So, Kasturi, coming to you, as a student, some of you may probably not know, Dr. Kasturi has taught in the Gandhi National University, has also taught in the KIIT Law School in Bhubaneswar. So, Kasturi, you had an experience like me in that sense, to having taught in the National Law School, also having taught in the state private leading law school, and also being an alumni of Law School Bangalore yourself, having specialized in human rights, having studied international human rights law. So, what do you see? Just that, what is your experience of environmental law teaching, which you have done at some point in time in your life, that from the National Law School to the private law school? Does the sphere of environmental law teaching changes? Is it that the national law schools have been doing it some kind of, I would say, greater justice to the legal education in that sense? Or is it that the some private law schools, on the contrary, are doing probably a better job? Right. So I'm being very open. I would, say that I'm being very open critically about it. That what is your take as a law teacher on that?
Okay, Nachiketa, evening and good evening, all the respected speakers. Evening.
Kasturi, you have to be a little louder because we cannot hear you probably.
Evening, Nachiketa.
Yeah.
Choose to fit in at this moment after having hearing so many legal luminaries. But my take on this subject of environmental law is it is yet to be perceived as a core legal subject in or core legal area in national law schools, be it national law schools or be it private university. There is a kind of structural sidelining that we see that the subject environmental law faces. Like few of the points have already been mentioned by Nachiketa and Pushpesh sir. Like Nachiketa mentioned that it is always given to a young teacher. I remember when I joined academics as a fresher, I was also given the same subject to. Now I won't say I was a bad teacher or something, but yes, after having did now that I have a 10 years of teaching experience, now the kind of interlinking or the kind of exposure or the kind of amenities the subject can provide, I have a better idea about the subject than what I had as a beginner. Now, another important thing that I realized relationship environmental law standard legal areas or legal subjects. Like while the syllabus is framed, when we talk about constitutional law, talk about criminal law, or when we teach administrative law, why can't a small aspect of environmental law be integrated into the teaching of these various subjects? Small aspect of environmental law. And other than that, the semesters in which the subject is introduced, in some places the subject is introduced at sixth semester, eighth semester. So in which year a child is being subjected to the subject of environmental law? Now, can we assume that the environmental law students have learned disseminated enough foundational legal knowledge that we expect them to apply in challenges or the problems or issues of environmental law? That is a kind of assumption that we carry forward while subject environment is taught at a higher semesters like seventh or eighth semester. And second, as Sharad has very rightly pointed out, India is a nation where the conflict between your environmental protection and economic development it comes alive, and the time is ripe. This is the time when whole idea or the restructuring course in the sense that how we want to project the course. Say we talk about conservation and law, or do we want to say vis-a-vis economic development, right? So what are the takeaways that a student take from the environmental law courses? Like that is something which I find missing in most of the law school syllabuses. Like India is a party to a lot of multilateral environmental what do you say agreements.
Treaties and agreements, yeah.
Yeah.
Agreements. I hardly find a kind of legal wherein focus is on analyzing or figuring out the gaps in the core areas or in the corpus of the environment and how much of an adherence India has to that. And mostly the saddest part is as even being a student at national law, while we were studying international environmental law, which was an essential part of our international law, we are too much focused on the district law. So there is a kind of right kind of a switch. And I'll just take one more things, 2 points which I the law school curriculum should have, and you speak to them, they will say it's too dry a subject, it's very mundane. We talk about regulatory mechanisms. So hardly we are able to generate that kind of an interest in the student. Firstly, because in some colleges the students have the teachers have the complete liberty to frame the syllabus, and at times the teacher frames a syllabus which undergoes a lot of scrutiny. There'll be a committee which would approve the syllabus, and once the syllabus is approved, then the syllabus has to continue for 5 years, then again it has to be reapproved. I feel some kind of independence or freedom, if it is given to teachers to figure out the areas, which of course has to be linked with the UGC and BCC, Bar Council of India's standard format of environment. They can about the examination of current policies, national policies relating to various aspects. We can talk about executive, quasi-judicial, and all the judicial institutions which are up there as an environmental. These are certain things which I think should be good and which I found missing in. However,
Right.
the official are doing a little better than the practice.
I agree. Thank you, Kasturi. In fact, yeah, Professor Pushp Kumar, when you were a little away, so we were discussing all of this context, and there are two things which I take away from what Kasturi has said. One, that as Shavaik also mentioned, that there is a lack of aggression. There's a lack of charge the students in the classroom when it comes to environmental law teaching. It's probably done in a very subtle way, without making them realize that this is something, a subject matter or which needs you to come into action, right? Which is something full of action, and you need to take that forward rather than having just a theoretical understanding of it. Second takeaway, which I now get from what Kasturi has mentioned, that there doesn't appear to be much of a difference in the national law schools or any state private university, and probably what our two professors, Professor S.K. Gupta and even Professor Pushp Kumar has mentioned. Two of you coming from we say typically the traditional university, so to say, but the leading law schools. So what I gather now, the picture is, and I having to add to my experience, I started my law teaching career from environmental law. So I again get to relate with the same thing, that I was the first, and I mean, my first entry into the legal academics was with environmental law, right? Probably owing to the factor that I was coming from RLEK, so it was understood that I'll have a better, sort of a knowledge of the environmental law, mainly because of the only fact that I work with RLEK because I filed the first environmental PIL. Right, so that doesn't appear to be too plausible a reasoning as such, but nonetheless, that is as it existed that time, so I had to teach. So now coming back to another interesting factor, and the question for the second round of discussion with Dr. Pushp Kumar is that, so you have been a Fulbright scholar to Harvard Law School. You have, been lecturing and making presentations in a lot of law schools in the United States, even in Europe. So what is first question, what is your take that how do you see the environmental law teaching in the West? Probably, is there something that we can use as a matter of best practice from there? And have you tried that at your end? Would you suggest something of that kind? One. Second question, that is there something you would want to recommend in terms of revising up not just the syllabus of environmental law, but also bringing a pedagogical change, that there needs to be pedagogy change in the environmental law teaching? So these are the two questions for you. You need to unmute. Yeah. Can you speak now?
I think now. Is it clear now? Is it audible?
Very much. Very much.
Very good. Yes. Thank you very much. I think, I was, all through I was here only. I just muted my video so that the bandwidth is not affected. I heard, the other, learned speakers. One thing, I just want to clarify one doubt, that Shavaik has, Mr. Shavaik has, mentioned that maybe I have not conveyed it, clearly. I'm not that, taking one side of that, we need to create, students passionate about law, environmental law only, not about the active practice and, not to expose them towards, the lucrative practice that is possible in environmental law. It is not the sense in which I said. We need to do both. And we need to really, provide all opportunities for our, students that we are doing. I myself, I know we are doing it in our law school. We are doing it. There are many brilliant students. They pick it up and they argue in both sides when we teach. So I think that is not the point that I raised. And coming back to the question that Nachikheta has raised here. Really, I was I was very fortunate to visit some best of the law schools, around the world, where I could see some best practices. Okay, what is lacking here in India, and what we can take, cue from them is, in terms of the practical aspects that they, provide in teaching the theoretical aspects. So that is where I think, we need to learn, we need to bring such, elements here in our, curriculum. One thing I will tell, any paper that they study there, not only environmental law, there is a research component. So every paper here, I see that I also taught in National Law School, then came to, Delhi University. So I got both experience. In National Law Schools, now we see in India that, there is a kind of a comparative, freedom for the teachers to innovate the curriculum quickly. And also, if you want to include the research component, you can do that by writing research papers or assignment. And that aspect is very much available here. And that is the core element there in the United States as well as in the Western universities. So any paper the student has to study, that should be, analyzed, threadbare, and they want to come out with a contribution, a paper, and that will be assessed and they will be given a grade on that. That is one thing that, we need to understand. And I'm really, difficult to say that, such a possibility is not available there in the traditional, law schools. Maybe, we are trying to, but, making, use of this lockdown period, I engaged my students to write, assignments, even though it is not going to be graded. And second point I want to tell, how the law schools in the United States, particularly I have the experience of the Harvard Law School. What do they do is, they, as Shavaik has pointed out, there are two faces of a coin. You have to prepare the students with the skills of effective lawyering, defending the industry as well as defending environment. Both you have to do. That is happening, and that happens at the very practical level. The students have to engage with the environmental law clinics. So they have to demonstrate how interested they are, how they will write the pro bono applications. All those things they have to demonstrate. And pro bono applications doesn't mean it is only in favor of environment. It is for both sides. So one thing is that they give more value to pro bono work, court-based work during the study itself. So the center like the Environmental Law Clinic will be engaged in submitting pleadings to the courts, and the input goes from the students with the help of the teachers. And that I think we need to pick up from such law schools. So students are really learned, they are given right kind of readings, and they have to understand the points. And the live cases, as it has been stated that we are stuck with Gopal. I completely agree with them. We are not really connecting with the modern aspects. And how they teach law is that if I'm teaching environmental law, particularly on the compensation related case, immediately the live case will be discussed in the class. The live cases will be discussed in the class. Already 4 hearings have been done. Then the next hearing is going to happen next week or next month. What will be our contribution? So that kind of a discussion will happen. Then immediately, there are always possibilities there. They will be, the environmental law clinic will be implemented as a party. So they will give, the amicus briefs. So such things, the students are engaged. So I think, the practical aspects will give them the scope to understand what really law is and how does it work. And that aspect, if we are able to bring it to India, I think they will become effective defenders of environment on both sides. And why I insisted in my first part of my talk that we need to create such a sensitive, students, because normally when we prepare the law students, they pick up the lawyering skills. But what is lacking is they don't pick up the values that are behind that. So we need to bring those aspects. I see, for example, we have read in history that Rajaram Mohan Rai, okay, so he was instrumental for eradicating, sati. He was instrumental for bringing the act, Sati Abolition Act. It was there for years. It was there for hundreds of years. The practice was there, and the sensitivity was not there with the people. And he got aroused, and that became a change, isn't it? So one person, our real thrust should be engaging everybody in skill development, understanding the real nuances of law, and again, creating such leadership. What I could see, if I can say one word for what is the difference between Indians, the law schools and I don't want to generalize completely. Just one thing, what I understood, I just say, in Harvard Law School, what I could understand is they create leaders. They create leaders, not just students, not just lawyers. They create leaders, and they will be leaders in wherever they go. They may be leaders in the bar. They will be leaders in, industry. They will be leaders in defending. So everything they create, that I think we need to do here.
Right. Thank you so much, sir. In fact, I really agree with you on that note, that probably one of the elements which is missing is not just on the level of pedagogy, but also at the level of the culture of teaching in general, holistically. That what we are doing is probably, I'm sorry to say, as academicians, somebody could also contradict me, but that is okay, because that's how we academicians are open to a lot of subjectivity that ways. But as I see today, sir, having worked in the legal academia for a long time now, that probably under the wraps we are creating mediocres. As you said, that some of the best law schools in the West are creating leaders. We probably are still not emphasizing or focusing actually on creating the best. We call that we are the best, but are we the end product, which is the student who goes out of the law school? Has that student acquired the necessary skill set and could be called as the best product is a different thing, right? So we are just trying to all the time harness upon just, I think, the top 5% of the students who may probably be, making it to the package of the bigger law firms. And on that basis, we generalize that we are the best law schools, right?
Exactly.
So, element that, yes, that the problem is that as you have said, that there's so much in the West where the live cases are given to study. And another aspect of the law school clinics, on which I will come to Professor Gupta to talk about, that they get to have a hands-on experience, not merely looking at the doctrinal part of the study of environmental law, which is given by a law teacher in the classroom, but they attach themselves with the legal aid clinics and the legal services clinic, and then do the work on both sides of it, not just from the victim's point of view, but also from the other side, maybe representing the state, maybe representing the company, because at the end of the day, for a lawyer, it needs to be a holistic. Yeah, you wanted to add something.
Can I just to add, I would like to add one rider. What I said, it should not be mistaken, in different context. So what I said is that, whatever I could see in the West, I lived with them, I interacted with them, I understood with the, whatever they did. I'm trying to only understand the best, how it can help us. And by no means I would say that, they are the best, or, we are not doing well. It is not the message.
Right.
It is only just to fill up the gaps. And I would like to, at the same note, I would like to say that there are wonderful teachers here in India. As a wonderful teachers, we are really, creating such, if I am sitting here with you, and it is because of my teachers who have given that kind of, the encouragement and the knowledge we have. So such teachers are there. Professor Jariwala, as Professor Gupta ji has stated. And I think, in my first response, I have not told when you said about the revisiting of the courses. The first experiment, really, it was perfect. In North India, in fact, Professor Jariwala started this movement, teaching of environmental law. You may be knowing very well. In South India, in fact, Professor Leela Krishnan, you all may be knowing his book. He started environmental law teaching. That was in 1970s, where, much before, nobody, people did not know about, it can become a subject, separate subject. They experimented with the subject, and they experimented with whatever we are thinking today, with research component, with skill development, with amalgamation of the practical sustainable development aspect. They did it. But somehow, I think, slowly and, gradually, we lost the track. And also, I think that, the project that the National Law School has done under the leadership of Professor Ramesh. Yes. I think, that was the really pioneering effort. I think he should be, treated as, the third, stalwart in promoting the environmental law teaching, where he has created the generation of environmental law teachers in the country. Okay. But unfortunately, that was in 97 or 98. It stopped there, by that time. Then after that, we did not have a follow-up. So we have, lots of teachers now coming up to teach environmental law, and the problem is more here now. I think we need to orient our teachers in a better manner. We need to come out with such, experiments even now. There is a gap now on that.
Right. Thank you, sir. In fact, I do agree. In fact, if you recall, my question was also that what is the best practice, not to indicate who is the best, right? Because the best practice is that something that we take a sum and substance, right? That who is doing here and there, and we could probably borrow. And the idea is also not to replicate, because we are different societies. After all, we have our own, inherent challenges and compulsions. So the idea is only to take what we can probably assimilate, right? Not to replicate it. So that's how I see the entire proposition. Okay. So coming to Professor Gupta, sir, you have been the executive director of the Legal Services Clinic and Continuing Legal Education Program in BHU. Now, which is one of the very interesting things. Why? Because I have for long years been working on the legal aid front. So what excites me to know from you is that has an experiment being done in BHU, what also was touched upon by Dr. Pushp Kumar just now, that is there any experiment present being done in BHU to connect the environmental law students as well as the teachers with the legal aid clinics, and this kind of a marriage of I would say, of the doctoral teaching and learning process which goes on in the classroom, along with that being blended with the hands-on experience during the services clinic. Has this experiment been ever there? And if you could just highlight that, and so just keep brief so that we can move on to the next round of questions. Yeah.
Dr. Nachiketa, from 2013, I have been working as an executive director of the Legal Aid Clinic. Right. Before coming on my experience, let me tell you that I taught environmental law for perhaps about 8 years in my law school, and from perhaps from last 8 years I have stopped teaching environmental law at MAT. But I was teaching a paper that was known as the country and town planning, and I'm showing one project, a small project that my student used to done. There were 60 students in the classroom, and I used to form 5 and 6 students as a group, and I used to give one topic for the field study. So this is a small project that is related to land acquisition and law and policy in India, Ganga Expressway project, a socio-legal study. Right. So this project, my students have come to know that this famous Ganga Expressway project, it required the EIA, Environmental Impact Assessment. Right. By that time, Sushri Mayawati, whose picture is there here, she was the chief minister of that time. And you shall be surprised to know when my student told me, on the basis of their empirical study, then the whole EIA clearance was given within 24 hours. It was the 1,000 crore project. and the whole EIA was cleared under the political influence of the then chief minister within 24 hours. So this kind of the practical experience which we have got, that is very important clinical aspects. But one thing more I would like to humbly submit is that I'm a student of jurisprudence also. And I understand that the jurisprudence is the mother of law. So if you want to understand the even the clinical, if you want to understand the law, I don't agree that only practical aspects is important. No, even unless you understand theoretical aspects so well, you cannot have the interest to go on the practical aspects as well. So that's why the theoretical aspects and jurisprudential aspects is equally important as is the practical aspects. And therefore, friend, I would like to tell you one thing. What is my experience is that uh, uh, I have the 80 students volunteer with me in the legal aid clinic. And what I have found that most of the time, students are very selfish. Most of the students, 90 to 95% students are very selfish, very career oriented. They join any legal aid clinic not on the basis of the pro bono. 5% may be exceptions. Most of the students, they come only for their career, just for a certificate. And that's why it is a great challenge. So I have found that unless you motivate as a teacher, that you have come not only for a certificate, not just for a career point of view or one point added in your CV, but you have come here just to help the of the poorest of the poor people, where 3 crores cases are pending, where the social justice is the soul of the Indian Constitution, when the delay is the very important issue here, where the criminal justice system is not working, where the right to speedy justice has become just a principle on paper, where the fundamental right to legal aid is only on paper, where all the institutions exist on paper. So I have to first convince my student jurisprudentially, theoretically, and then I will be able to motivate on the practical aspects.
Right.
And therefore, so if you allow me to say that, so as a teacher of environment, I used to tell my students, look, there was Justice Bhagwati in the famous oleum gas leak case. He has propounded the so-called absolute liability principle. With all due respect to students and panelists here, I shall be very happy if somebody tells me in how many cases the absolute liability principle has been implemented in India. It was propounded in the year 1990, perhaps 20th December 1986, if I'm remembering correctly, the oleum gas leak judgment. And I have found not many cases in which the absolute liability principle in fact has been implemented. And if you will see the famous Beacheri village case, even in the Beacheri village case, that principle has been casually referred. And I told my student that in the Beacheri village case, a judgment was given in 1996, but 10 years has lapsed and that judgment has not been implemented. It was Justice Baldari after 6 years that has delivered another judgment and he has said that these chemical industries, they have made the mockery of our judicial system.
Right.
And
Right.
sir, we have to understand the jurisprudence of environmental law very clearly, otherwise you won't be able to teach your students. Look,
Right.
if water is being polluted, if an elephant is being killed, and if a tree is being cut, the tree cannot speak. Animal cannot speak. Somebody
Right.
else has to speak for them. And therefore, you have to give standing. That's why it has been a question whether the tree should have standing or not. Okay. And that's why in India, I'm very sorry to say that most of the environmental law legislations, they exist on paper. After the Bhopal, you made the Environment Protection Act 1986.
Sir, if you, I'll have to move on. I'm sorry, I'll have to move on to Shavaik on that note, because my main concern was to look at that. How are we looking at the legal aid clinic supporting the entire environmental law teaching? But as you have,
As,
yeah, as
as
you
a legal
mentioned that there've been
as a
experiments done, right? Yeah,
as a legal aid clinic, I have enough work for providing legal aid to the 3 crores people.
right, right,
Uh,
right,
so
right,
I
right.
think that I do not
Yeah,
have the
yeah.
enough
I
time
I
for this
agree.
work.
I agree. I agree.
But
So
whenever we go for the village camp, of course we teach the villagers about the importance of sanitation, importance of the environmental
right,
protection.
right. So on that note, I'll just add another dimension to it. That I tried to experiment something last year when I was teaching access to justice course, actually, sir, at the LLM level. So in the National Law University of Odisha. So it was not the environmental law course; it was access to justice course. But since the course of access to justice is so vast, I incorporated an element in it, legal aid during post-disaster scenario, and also legal aid for the environment affected persons. And it so happened that when I was teaching, I was giving them the projects to go and visit the villages and try to figure out. They try to get in touch with the environmental agencies in the state of Odisha, in Bhubaneswar and Cuttack also. And I don't know, but it was just circumstance turned out to be so that in a 1 month's time, when they were doing a project, there appeared to be a warning of a cyclone Fani affecting the entire state of Odisha, West Bengal, and Andhra Pradesh. Right. So after that, after the entire devastation, some of my students, they've again reached out to these environmental bodies, though it was something which is not man-made, right, or propelled by the human machines. So then they try to take a stock of the situation, that what the law students through the legal aid clinics can do, even scenarios where the environment might have got affected, maybe not because of the human reasons, but what is the compensation that they can try to think about for the people who have left lost their property, their houses, so on and so forth. So what I'm trying to just add, and digressing from here a bit, is that similar kind of experiments could probably be done more profound level with regard to exclusively the environmental law teaching. I try to experiment it with the access to justice component, but if that kind of element could be drawn and stretched in the environmental law domain as well. So that's for all of us to reflect together, maybe later on. So now, Shai, coming to you, that that you have been assessing the interns also. I know that I have also bothered you previously to accommodate a couple of interns once or twice, right, during the vacation, because I was handling the internship and placement for long years. So what is your one assessment, that how do interns look and contribute in terms of environment law exercise as a practitioner? And second, that from your perspective, what is that kind of a suggestion you would like to give, which can be takeaway for all of us together? And we have, with us on the screen, the professors who have been teaching environmental law. I'm temporarily out from the institutional law teaching, though. But I have the professors who does that work all the time. So what do you think that they can incorporate? Probably you are in Delhi, Dr. Push Kumar is also in Delhi. If you want to partner in some kind of project of that kind, so what would that be?
Chiketa, I get interns from all over the world. And recently I've been getting a lot from South Asia, because as a law firm, we have been now working on modernizing South Asian environmental law treaties.
Right.
Mainly the water ones and the trade between India and Bangladesh. Those are treaties of the 70s, and we said they should be mainstream. Now, the problem I see, I'll talk about the Indian students, because foreign students have got a very different orientation. They're not clued into the landscape of the country and the geography, so on and so forth.
Yeah.
The problem with the Indian students that we have realized is that they are very articulate when it comes to, for example, national law students, national law school students, or from many other, even government law college, Mumbai, fascinating. So students very articulate, they can draft, they got the requisite legal skills, they've got very fine understanding of case laws and jurisprudence, but they're completely clueless about the geography, the ecological aspect of it, and how the reality looks like. So my view, I mean, the opinion that I have come to kind of take from experience of 10 and 11 years of handling interns is that environmental law has not to be taught only in the classrooms. So classrooms are good for trend analysis, for jurisprudence, so for reflection in terms of where the law is going, so on and so forth. But it has to be very much on the mangrove sites, on a chemical plant. They have to be told. I mean, not many students, for example, know in India where are scheduled areas. What village forests look like. What is the difference between Schedule 5 areas and Schedule 6 areas? That is how the law plays out in environmental cases. It's how your environmental clearance for coal mining will be different in Schedule 5 area from that of the Schedule 6 area. So these are the intricacies of the law which students at the very college stage have to be kind of made to interface with. That's the first point. The second short point is that students have to be demonstrated the side of environmental law. For example, the sheer economics of it. Now, no investment is possible, no large scale economic development is possible unless you have the environment side management done. And you need a battery of lawyers to do that. Then the respect and the prestige part of it. For example, not many know that legal profession is the most sought after profession in hydrodiplomacy in South Asia. So we have these large water, reservoirs or water treaties between India and Bangladesh, India and Nepal, India and Pakistan, and you need legal expertise, domain expertise on water treaties and water negotiations and international law negotiations to kind of be part of government of India in some capacity to kind of support that. So the corporate side and the legal. Then there are niche areas which I don't think many law schools talk about. For example, not many schools talk about that there are these special interstate river tribunals where the practice goes much more, in terms of content, in terms of opportunities, is way, way ahead and forward than the practice in the Supreme Court that you see. Only very few lawyers are able to make to the river dispute tribunals. So I would say that combining what's happening around us and putting it all together cumulatively, internship has to undergo, and classroom teaching has to undergo a kind of a very revolutionary transformative change where a part is taught in the class, the orientation is done in the class, whereas the interface is done where the problems exist. And then the teachers have to be your NGOs, your villagers, even the clerks can teach you a fine environmental law, because the procedure, the sheer evidence and the procedure of filing environmental case is not a very regular procedure that you might follow in, for example, in a civil suit or in criminal case or a PIL. So environmental law has got a lot of science and factual interplay at play, which only a thorough clerk can navigate you through. So that in simplistic terms, it's a very theory practice interface that has to now come to the classroom.
Right, right. Thank you, Shivaik. That's a wonderful take, because I do agree that a lot of it has to be in terms of venturing out of the classroom. That's the reason I cited an example where I was teaching a course on access to justice. So when it was taught prior to me, I mean, when I was on deputation Supreme Court, so when I went back to National University, so I was given to teach that subject to the LLM. So I discovered that previously it was taught as a classroom course. So my take was, because I have been working with the Gram Nyayalayas all the time. So I said that access to justice is not a theory thing. You got to go out of the classroom. So I took all the students of LLM for good 5 to 8 Gram Nyayalayas across the state of Odisha in the entire semester. I used to start at 5 a.m. in the morning and come back only by 11:30 in the night, because those were far from the university. So it used to be a good trip of 500, 600 kilometers a day, right? So the idea was that you have to go there, look at the entire thing, how the Gram Nyayalaya is functioning, try to also figure out, the mobile Gram Nyayalayas were organized in far off pockets apart from the panchayat headquarters and so on and so forth. So likewise, I remember some projects that I was also doing in RLEK days. These, differences of, for example, PESA, they don't know about the PESA, things at all. So these kinds of aspects are really missing from the classroom. In fact, if I'm not wrong, the 73rd, 74th constitutional amendment is hardly taught in the
No,
constitution
it's not
law. Right. So I remember that recently I was invited by National University Ranchi Vice Chancellor in December last year to teach decentralized governance course in the LLM there. So because I did that as part of my human rights course in law school Bangalore. So that's how I take it, right? So when also it has to be very specialized. For example, I remember we were only 10 students in law school Bangalore in the human rights specialization course. In fact, Kasturi has been there with me. So as opposed to a batch of 15, the corporate law specialization. Right? And when it came to further down the decentralized governance course, the number got reduced, including me, to 3. Right.
Yeah, that's all.
So that's how it worked. So, but I must tell you, it was a very exciting journey because I got some of the very good teachers like Professor Abdul Aziz from Institute of Economic and Social Change to come and teach, which is a adjacent institute to Law School Bangalore, to come and teach the course. So that's how. But he again took to the field trip. When I was studying the refugee and humanitarian law, then Professor Vijay Kumar, he took me to Bailakuppe to the field trip again to look at the Tibetan refugees, because otherwise how would you understand that what they go through?
No, you
Right?
can't.
So that's the idea of teaching with, that's my thing of adding on to the entire proposition. Now coming to another very interesting aspect for the law teachers, is going to be really relevant, my dear friends, asking Kasturi that what is your Kasturi, having spent time in the academic side for a good 10 years, that is the component of environmental law teaching adequately covered in the refresher training courses or the faculty development programs that we have across the board in any law school? One. Second thing, that how do you reconcile with this entire exercise of specialization of masters of LLM, that is there, you see a lot of masters program in environmental law? If not, should there not be a special component of environmental law, at least in human rights or some other discipline? So what's your take on these two things?
Thank you, Nachiketa. I hope I'm audible. Now,
Yes.
coming to the first part of your question, which is about the component of environmental law teaching, whether it is adequately being covered in most of the faculty development programs or in kind of refresher courses. Okay, I'll just tell you two instances. My research says that, or I have attended one of the courses, like refreshers course of law teachers, which was organized by NLSIU, that is National Law School Bangalore, the year 2018, was the first time when a specific component, a specific slot was given to teaching of environmental. And further in 2019, when they came up with the same course, refreshers course of law teachers at National Law School Bangalore, they talked about the practice before tribunals and NGT of human rights law and environment. Other than that, there is SWAYAM. We all know about the SWAYAM courses and various other UGC sponsored staff academic refresher course. I'm sorry to say, but so far I am yet to come across any syllabus which covers environmental law in particular. Right. So, and broadly, as I have already mentioned, that broadly it is covered under your international law or human rights law.
Right.
Okay. Now, coming down to the law teachers training, there are few things that I would like to mention. That one of the difficulties for teaching environmental law, that matter in specific, or for any other law subjects that we face, is the pedagogy. Right. The pedagogy. What should be the exact pedagogy? We learn by the trial and error method. Some of us, learn quickly. Some of us take time to learn as to how should we be teaching. What are the skill sets which is required, or the techniques which are required to teach the grown-ups, to teach a professional. Because there is a complete aid or nurse teachers training. There is a skill that is imparted to the people. The certain techniques which they learn out of those courses, that is completely missing as a. One aspect is inclusion of clinical legal education. Second aspect is your teaching and learning methods. And third, very important aspect for person like you and me, like today, because of family issues or because of my child being small or because of me being located at a small place and not being affiliated to any institute, I am not, I won't be entitled to do any kind of refreshers course. Even if I want to, I would have to establish a kind of. I have to establish kind of my, association with the institution. However, that kind of restriction which is there should, they should have some relaxation to people who genuinely want to learn and they don't have affiliation to any kind of educational institution. So we should be allowed. So it's a request to all the senior teachers here, if you can make some changes there. Maybe we return back to academics in 10 years time, but we would, because of the love of teaching. And secondly, coming now to the second aspect of your question, wherein you asked me about a specific LLM program for environmental law. Now, again, we know that it is broadly covered in international law or human rights. That is one way of teaching people environmental, but I would vouch for having a separate program for environmental training in environmental resource, instead of only associating it with constitutional law, administrative law, criminal law, which are the standard core papers, we can try and relate policy, energy law, so some issues like pollution, toxic substances, climate change, so many land use management. Like few days ago, we knew about the poor elephant who passed due to a cracker which burst.
Yeah.
Now, we all moved from a very sensitive issue of human settlement in the forest land. That is also a very important aspect.
Kasturi, just bringing you back to another issue because Dr. Push Kumar has to leave. He has another webinar to attend. That could you? I got the first part of it. The second part, what about the specialization at?
Can you just repeat the question, Nachiket?
What about the specialization at the LLM level? Specialization of environmental law.
In environmental law, if a separate program can be introduced, because these days in private universities, until and unless there are requisite number of students, they don't offer a particular course. Like we need to have 10 people to enroll for them to start the human rights law, or you need to have 10 people to enroll to start the international law. So at times, people who are interested to study environmental law, because of low takers of human rights or constitutional law, this thing, people are unable to study it. So, but if a separate program is introduced wherein energy, resources law, energy law, mining, there's so many issues, land issues, and environmental assessment for that matter, the economic aspect of it, protection of diversity,
Right.
all can be together, and if we get a specific course, it would be good.
Right. Yeah. Thank you, Shivaik. You wanted to add something.
Just an addendum to what Kasturi is saying. So Global OP Jindal Institute has started LLM Environmental Law. There we have the similar issue. We have just got 6 students there, but each of them I asked have a reason to justify how environmental law specialization is going to help them in their MOEF job or Ministry of Corporate Affairs job. So I think that point is valid, that you need a certain amount of students who kind of start a course, which universities face difficult to find. Yeah.
Yeah, because that there's a practical reason of cost analysis. It has to, after all, generate revenue for the universities. To run a course is always being, you will bring in for example, a specialized course. You will have to try to reach out to expert resource persons, and nobody would do.
I'm sorry, I'm cutting.
No.
You made a very good point. You said, economic gains and, cost benefit analysis. So are we imparting legal education to fill in our pockets, or we are imparting legal education to enable students
No,
to develop
Very debatable.
No, I agree that's debatable,
So
but
why we are offering legal education? I think we
yeah,
should.
but my take is middle path. To reduce the cost of legal education. It's not just about making money too much, because what I see practically on that side is that you anyhow need to be economically viable to run any organization, for that matter of fact. And especially in the contemporary time, if I see, most of the universities are facing challenges to pay off the salaries, right, because of the economic slowdown. And I know that some of the national universities are also looking at the salary cut because they probably do not have the sufficient corpus. So there I see the reason of economics definitely coming into play. And it's, for example, I know, Kasturi here on the sitting, you yourself, that to tell everybody, till April I was working as a dean in a in a university in Gandhinagar. So since that time when I was the dean and till now when I started a virtual law school, Kasturi for last 3 months has been teaching pro bono. So Kasturi, there would be very few people like you to do this kind of an exercise, and I have left a very well paid
Lawyers
job.
have livelihood issues. Lawyers have livelihood
Right.
issues,
Lawyers
Nikhil.
have. I have left a well-paid job in pandemic, and I am doing pro bono law teaching for last 45 days. Right, but that's a different model that I'm looking at altogether. So I am not going to blame anybody who is looking at the very commercially exploitative or being a viable, whatever economically healthy model. It's for them to reflect upon that. Right. So coming back to the main issue as we were discussing, my dear friends, one that my takeaway from today that this environmental law teaching definitely needs to be strengthened by plugging the gaps as we all have discovered by now. And what was coming to my mind as a thought process was that I would want to do in fact a paper on this, right? Probably Professor Pushp Kumar, if you want to think of doing that, we could do it together. Kasturi,
Yes.
Professor Gupta, we could probably Shavaik, we all
We can
can,
jointly do it.
yeah,
Yes,
we
we
could
can
pitch in
jointly do
as
it.
a joint panel and do a paper on this, which we can definitely get published, that how the law teaching and environmental law discourse, coming to terms in terms of being compromised over the years. And I think there's no second thought on that, that it has definitely got compromised, be it for whatever reasons. Reasons will be disruptive for the purpose of the academic debate, but at the same time, reasons have to be also addressed adequately, because otherwise we would be again second year meeting with the same debate, right? So it would be a vicious circle with only the debates coming in. And in fact, Shavaik, when today I was planning this entire event, my entire thrust as a law teacher was that with all due respect to a lot of judges who have been supporting me till now, it's not about the speeches that I want to hear on as a law teacher. I wanted to see that what we can do as part of our jurisdiction, our process, something which is within our control, within our limitations, right? So that's where I wanted to make a difference. And that's the reason to tell, in fact, taking another point from what Professor Gupta said, with regard to students come, they look at certificates, they are important, no doubt. In fact, to tell you, you may see a very less attendance in the program today. One of the reasons is that since last 45 days, I have been conducting a lot of guest lectures. The students have been asking me. I say it very openly. Some of the students are also here, and I know they would take my point in a very positive way. That I would also make it recorded and put it on the YouTube. I don't mind doing that. That my take has been always that, sorry, I will not be able to issue a certificate only for you to attend a lecture, because it has not added a new skill set to your armory. But attending a lecture is also important because you participate in the process, right? So since morning I have received a lot of requests, sir, if you're not giving the certificate, sorry, we will not be able to attend. I said no problem, because for me the importance is, if you are actually relevant to the debate, you will automatically come in. Certificate cannot be a guarantee to bring you to the table of discussion. And that's why I kept it open for all the law teachers and law students also, that come and interject. So now on that note, I make it open for some of the participants there as the students. You please feel free to say whatever you want. I will be happy to put forth your your issues here, or what, since we have a very small number, I can do one more thing. I can sort of unmute all of you from my end. So if you want to participate, you can do that. Somebody wants to put it something in the chat box, feel free. You can mute yourself. You can. I'm unmuting yourself. After that, you will be able to mute yourself by yourself. So anybody wants to say anything, you're most welcome. You can also type in the chat box, my dear friends. That's perfectly okay with me. I can read it out on your behalf. Okay. Okay. So that probably, yeah. So everybody who wants to say anything, you're most welcome. Yeah, now I see something coming in here. Rahul says, I completely agree. There must be some students who are looking for certificates, but yes, overall self-awareness is necessary. In the end, your knowledge leads you to not your certificates. That's true, Rahul. I know, because at the same time, I may add a point. I may add a these collection certificates actually will not be looked upon too impressive even by the law firms once you will reach out to them, because everybody knows that during the lockdown that's what was happening. So yeah, coming to the point, if Rahul, you want to add something, or Krishna, you want to add something, Isha, somebody wants to add, Elvin, you want to add something, you're most welcome. Otherwise, we as the professors, we definitely will have a, closing remarks, and we can then conclude the program. Ravindra, do you want to add something? Hello?
Hello, it's audible.
Yeah, go ahead. Yeah, go ahead, Ravindra.
I want to ask that this is to the Pushpa Kumar, that how in this lockdown the environment, as it has been considered that it's recreating itself, has to be considered with intellectual property and environment, because he has that kind of both the aspects. And then this, considering this aspect, how can we deal it and how can we take it to the students so that it can be overall expanded and taught to them with the interdisciplinary module or interdisciplinary school?
Yeah, thank you.
Go ahead.
Yes, sir,
We'll
please.
collect the questions. Okay.
I think you can go ahead. We do not have many questions as such coming in. Yeah, you can go ahead.
Yes. Thank you, Ravindra, for this wonderful question. Actually, you have really connected an important point that we could not discuss. Environmental law is indeed an interdisciplinary subject. It's a very special subject, I said, but it is an interdisciplinary subject indeed, that it cuts across disciplines. And where, in this lockdown, as you have stated, that there is no doubt that we have seen much improvement in environment. And that's because of lots of inaction. So transport is not there, industries are closed, and all other activities are closed. So there are no vehicles around. So the pollution level has come down. Okay, so that is one thing. And it has told us, the message has been given to the people that if you are able to physically bring down the pollution levels, your life will be phenomenal. So this is the message we have been always suggesting, but we could never, bring out to, a reality. Now this situation has brought to us that, if you could reduce pollution levels, then, water quality will improve. You can see the clean, air and clean sky, and the biodiversity will improve. All these things are possible. And here in this context, how we will connect the intellectual property rights and the science and technology here. Okay. So the point is here that all this can be made possible with the help of new thinking and innovative, efforts. So there, I think, the innovative solutions with the help of, new technologies, once the lockdown is over, then again, we are all going to drive. We are all going to open up all these, shops. We are going to, start the manufacturing process. And we should not go back to the square one again. The problem, we used to face should not happen. So for that purpose, what kind of inventions and innovative things we need to do? And in that case, if such measures are there, intellectual property rights gives you two weapons. One is that, it tries to protect the interest of the creator, the inventor. At the same time, it negotiates a kind of, quid pro quo with the societal needs. Okay. So when you effectively protect such innovations, then how can it be in the interest of public also? Okay. So that kind of a solutions, I think, we need to think about a new, discussions on that. Okay. The technology, which is eco-friendly technology, how it can benefit as if I am an inventor, at the same time, how it can be widely used for the benefit of the environment and for the people. I think that kind of a discussion has already started in intellectual property, discourse, and it has to come to limelight now. And it has to be made, in a wider circle. And we have, it is like example that, you need, wonder drugs, the life-saving drugs. And when it is patented, it becomes, very, non-reachable, medicine. Then what is the use of it? isn't it? If I have to pay 1 lakh rupees for having one dose, then it is not possible. It is like I don't have the medicine itself. So that should not be the case. It is just I'm equating that example with this situation. So we need to create such innovative methods so that the IP protection also helps your environment protection.
Yeah, thank you so much. Thank you so much, sir. Okay, we'll just take quickly 2 questions because I know Dr. Pushp Kumar has to go. That okay, Pragun, you wanted to ask how should tourism with environmental protection be developed? So everybody who wants to take up that question, maybe Shavaik, you with your practical exposure, how should tourism with the environment protection be developed? That's a very open-ended question, though.
Yeah, right. So there is both. I mean, there is enough legal space within the statutes for regulatory authorities to take preventive actions and precautionary actions. I mean, we have established principles called precautionary principle and so on. So for that being the academic side. Now, so the whole theory of carrying capacity and whole notion of eco-sensitive areas and eco-fragile areas is now a full body of regulatory regime in place. And many states have in fact implemented the green laws and the ecotourism and have combined together and come up with state specific guidelines. For example, Himachal Pradesh has this kind of a toll tax where a certain number of vehicles can enter into certain areas. Meghalaya has it in certain areas. So the tourism and environment, it's a well developed domain where regulators and its states are very, very cognizant about it. Now, what is not happening is effective regulation in protected areas. So you have these national parks and sanctuaries where safaris are allowed. That's something we have noticed. For example, Bandhavgarh National Park, it has got a huge footprint. Now there is this huge pressure of hotel lobby. The tycoons like Make My Trip and tycoons like Yatra.com, and this is all in excess, where states are more and more giving relaxations. So statutes and regulatory regime is in place, but implementation enforcement is not happening. That is where a citizen's role, sensitize the students' role comes in, where the regulators have to be made more accountable, and somewhere the balance has to be struck down. Law is there, the enforcement has to happen.
Right. Thank you. That's a wonderful, pragmatic take on the entire situation, and I must say, quite bold take on that entire situation because you are a lawyer, so you could do that. Okay, so there's another.
Add a point. Can I just add a point?
Yeah.
Actually, this is wonderful perspective at what he has stated. And I would like to tell that, I got an opportunity to work in, Bihar for some time. I worked in Nalanda University. Okay. So where, I could find, because, it was again an interdisciplinary course where, the science students come to study law. So where, we need to bridge the gap of, how the science can be used to study law, and the lawyers can use, science to understand it. I could see that, Bihar, for example, I'm just giving, Bihar is you can say that it's a museum of culture, it's a museum of history. Everything started there. Okay. Every street, every village will tell a story about, Mauryan Empire, or about the British story, or, everything, or Buddha story, but unfortunately, our states have not understood the real worth of their own wealth. So they are all in such a bad condition. They are not maintained. They have not made use of it. If the same thing can be used, and they are in such a, the lap of the nature, isn't it? If we can just tap that resources, saying that, this is a memorial, or this is the monument, or this is the place where, Buddha used to sit, like that, if you are able to create this as an ecotourism spot, okay, so the Bihar will be within 5 years will be kind of, well-developed state, because you can also generate wealth from that, generate economic resources from that, and moreover, that resources may also be a part of it will be sufficient for conserving the nature there. And in the same time, the people's livelihood will be protected. I think, such a thinking has to come. And our students worked on such projects. I would like to say that.
Right. Yes. Thank you. So we'll take one last question. There's Krishna, who has been a student at the Virtual Law School. So she wants to know that to make environmental law more interesting, would it be better to integrate the subject into other areas such as traditional knowledge or even human rights? So I leave it open for anybody to answer that. Yeah, probably go ahead, Shumai.
Okay, so Nachiket, important point which I should have probably said earlier and cuts through all that we have deliberated so far. Now, that being, as practitioners, we kind of compartmentalize body of environmental laws into two. One is set of Brown laws, which is associated with pollution, chemical industries, the Environment Protection Act and the rules issued, the hazardous waste, etc., etc. The second is what we call green laws, which is Forest, Wildlife, Forest Rights Act, and PISA combined. Now, the practice, in terms of practice, these two domains are entirely different. They do intersect with each other, but these are different. Now, for example, there are areas where I'm answering the question now. Now, there are areas where traditional practice cuts through environmental legislation very clearly, and not a lot of research has happened. In fact, this is a very pregnant area for law professors to take up. For example, in the Forest Rights Act, there is a provision which says that uh, intellectual property associated with the traditional knowledge is one of the forest rights, one of the community rights. Now, there is no research so far. What is the intellectual property associated with traditional knowledge and how can it be given to communities? You link it to Biodiversity Act 2002, where there is an NBA mechanism where access and benefit sharing has to happen. Now, these are the creative areas. These are the legal spaces where a lot of work has to happen. And therefore, as an answer, I would say, yes, it is possible to link traditional knowledge, which has also been given the statutory importance, has been statutorily recognized within the Biodiversity Act of 2002, link it to the rights regime under Forest Rights Act, and so on and so forth. And therefore, one can work across the legislation and kind of see through that traditional knowledge is kind of respected and is acknowledged and given the due importance in intellectual property as well.
Right. Thank you so much. I do agree with that. Yeah. So do you want to add something?
I'll just simply say that I've done a lot of good work on traditional knowledge and environment, including intellectual property rights. Ravindra knows it. Ravindra himself is a IP law scholar. So if anyone wants to, I don't have much time because 6 o'clock there is another program. So if anyone wants to definitely work on it or want to know more about it, kindly write to me. I'll be very happy to engage with you.
I'll be happy to share the email address of sir. So thank you, everyone. Thank you, Professor Pushpkumar, Professor S.K. Shrivastava, Shoaik, Dr. Kasturi. Thank you, everyone, for coming today. On a very short notice, though I bothered all of you, but you all have been very kind to me to give at least your almost couple of hours for the discussion today. So thank you, my dear students. Some of you who could stay longer with us for the entire discussion. I really thank you and value your attention for this important discussion, because my idea today was that it should be a participatory discussion where the teachers and the students could collectively think through that how to do some kind of a change in the environmental law teaching. Yes, sir. Please go ahead.
Dr. Mittal, before we should conclude, I would like to say one thing.
Yeah.
And that is look from the student perspective point of view. This is the economics has always been very important for a person in our life. In our traditional value, dharma, artha, kama, moksha. So this earth has been one of the very important value in Chatushta Purushartha. So look, the National Law School culture, a student generally pays 2 to 3 lakhs rupees per year. And when he go for, so after paying 10 lakhs rupees or 15 lakh rupees, and then if he does LLM, again 1 lakh rupees he has to pay. So when he is spending the 16 lakhs rupees for getting the legal education, naturally he will think for the quid pro quo. So when he is not expecting this more than 16 lakhs from the environmental law lawyering or environmental law advocacy, perhaps he will not pay the attention for that. And here the role of teachers has come. My point is that we are not making students only professionally competent, but we have to sensitize our student that this is a noble profession. They have to be socially committed lawyers also. And here in this context, I would like to say that a student, okay, you have to earn the money, lot of money you should earn. Okay, very fine, but not at the cost of the environment. You have to be, your life and your profession and your job has to be environmentally sensitive. So whatever you do in your life, sustainable development must be your goal. And that's why Rio Declaration specifically says that peace, development, and environment, these
Right.
should not be taken in isolation. These things should be taken in together.
Right. I respect that, sir. Thank you so much for your valuable opinion, and thank you all, my dear friends, for coming and thoughts on this important subject. So, sir, without much making you wait, rather, Dr.
Such a
Pushpkumar.
pleasure.
Yeah,
Such
yeah.
a
Thank
pleasure.
you.
Yes.
We will reconnect
Thank
again
you.
and try to plan
We will meet again.
something
Yes.
better. Yeah.
Thank you.
Thank
Yeah.
you.
All the best to everyone. Yeah. Thank you.
Thank you. Bye-bye.
Thank you, students.
Thank you very much, sir. Thank you, students, everyone. Bye-bye. Thank you, sir.
Yeah. So, bye, sir.